Bam. We're going live tonight on YouTube. We tried to do it on Facebook, but I think Facebook has me in, I'm in Facebook jail. But that's all right. Out of the way here. Because I got YouTube. Live on YouTube. Yeah, YouTube likes me. Going live, baby. It's loading. Almost there. Bam. Here we go. Here we go. Here we go. Hey, here we go. Here we go. Hello, everybody. Welcome to Advocates for Justice Foreclosure Defense Paralegal Service. We are different and we prove it. Hope you guys had a great day. So I usually don't come on till later, but I need to share an update on one of the documents that we're using to smash some people up in the face. But before we get to that, I want to thank all of you guys that have been supporting me here on YouTube. Today was a very important day. We got our first 1,000 subscribers. So now all we need to do is finish up. I think I need about 1,000 hours of watch time before I can monetize my channel and then reduce my prices again. So, everybody, more people can afford to get in and fight. I know people are struggling right now because I hear it all the time when people call me, and it's sad, but we're not out the game. So thank you guys for subscribing. And I want to show you guys in the end of this video what I've added to the package. And before we get to that, I want to thank Tony George for letting me know that that she did not have what she needed to get up in the judge's face in the package that she bought. And she bought her package back in March, I think she said. So I double checked on that, and you are right, young lady. So I took care of that. You check your email. You have in there your email what you need to not only recuse judge, you got what you need in your email to file your notice of claim against the judge. And remember, the notice of claim is the claim. So if you done plan, just take the notice out and turn it into your claim. And that claim, that notice of claim that I put together to go after the judge is some of my best work. And I'll tell you right now, that notice of claim is badass. That claim. Now, the main thing in that claim that you're going to be sticking in the judge's face is you're going to address the fact that the judge is violating the Administrative Procedures Act of 1946. Now, if you want to look this up, you have to put 1946 on the end of it, or you'll pull up Cornell Law Library full of watered down BS that don't have anything to do with the actual Administrative Procedures Act of 1946. Now, hang on one second. I need to do something. I'm really sure I'm going to like what I got to say today, so I want to go ahead and give myself the first like. So the Administrative Procedures Act is actually a federal law that was actually enacted in 1946. And I ran across I have used this to control some things. I have some stories, but we need to stay focused. This law mandates that corporations must have their policies and procedures in line with the Constitution. And they do not. And Now, when you go in with this, you're going to have the other things on there, you know, violation of your constitutional rights, violation of the color of the law, all those things. So we have all those things in there. But those are the things that you're going to claim the money part on. Okay, the Administrative Procedures Act of 1946 violation is not something that you can claim damages on, but let me tell you where this has the power. If you win in this, you can force the administrative court to force the corporation to change its policies and make sure that they're in line with the Constitution. And the corporation can't do that, because if they did, they'd have to go sit down, because they'd be doing things the right way. And if you're talking about the court as the corporation, because the court is the corporation, if you make the court change their policies, that's going to be a huge problem for them, because they would not win anything against anybody if they was doing it straight. And that's the fact, Jack. So that Administrative Procedures Act of 1946, that notice of claim in the packet, in the new magistrate judge reconsideration, is pretty badass. And if you don't want to just go ahead and file your lawsuit against the judge, which what I would suggest is they're throwing you under the bus, because at the end of the day, it don't matter who you sue. You need to be suing somebody for what they're doing to you. So it don't matter who it is you're suing, as long as you got somebody's butt on the hook. And the best person to have in there is that person that's blocking you from having your day in court. That's the way we roll around here. So the Administrative Procedures Act of 1946 is not something the judge is going to want to have to deal with, or the Attorney General, because when you file against a judge, you know, judge is a state officer. You would be filing, I am pretty sure you would be filing your lawsuit in the Attorney General's office, and the Attorney General is going to be the one that's going to have to deal with it. And that's why we have in the jurisdictional challenge with an affidavit, we have that set up to go to the Attorney General, so the Attorney General can see what's going on. So let's move on. I got somebody sending me a message here. Okay, so let's just go on. Now, a little later on in our stream, I'm going to show you guys the what the new packages look like. And oh my God, one of them has the non-judicial foreclosure package already had 16 documents in it, and then we added a few more when we added the new magistrate judge reconsideration package. Now, the magistrate judge reconsideration package, what I usually do with that is when the magistrate judge, you know, sticks his foot in there, I'll usually go in. And so usually what happens is the clerk or the district judge hands your stuff down to the magistrate judge. The magistrate judge does not have jurisdiction to be looking at any of your stuff without your consent, without consent from all parties. So that's a problem right there. But we take it a step further. When the magistrate judge makes a determination to dismiss your case and does all of that, then you can file your motion for reconsideration. But before you file a motion for reconsideration, you want to make sure you get file stamp copies of everything that you filed in the case that you want to go before the judge, okay, and that you want on the record for your lawsuit, basically. Then you take copies of those file stamp copies and you attach them to your motion for reconsideration. And then you file it back in the state court for the judge to reconsider. Because here's what happens. So they have you in an administrative court, or at least they turn the court into an administrative hearing anytime they can. And what they usually do is, if the potato is too hot for the district judge is going to hand it down to the magistrate judge, and the magistrate judge can go ahead and screw you over without worrying about constitutional rights, because they're going to say, you didn't object to having it because you wanted to hurry up or whatever. And when that happens, then you want to go ahead and get your stuff in front of the real, actually, you're not really worried about getting in front of the judge because they're all in on it. What you're doing is you're getting on the record all of the stuff that you need to have them look at, and you stick it back in the judge's face in a motion for reconsideration. And then once you do that, you can file your motion to recuse the judge. It's in the package, and you're filing that motion to recuse the judge because the judge is giving attorneys an unfair advantage and illegally throwing you out without jurisdiction. And once you file a motion to recuse the judge, then you come in behind that. I usually wait like 1 or 2 days and file your notice of claim against the judge. And this is if you want to play around with them and kind of beat them up a little bit in state court. Give yourself time to get your federal lawsuit filed. And then once you file that, if there's still issue, then you can file your notice of appeal if you want to send all of that dirt over to the appellate court. And a lot of times, if you're trying to get your foot in the door, the judge won't want to have to explain all this stuff. So they'll just reconsider. And I've seen that a whole bunch of times. So that's how you're going to handle the magistrate judge. So let's get over to the reason that I'm talking tonight, or I need to put the sanction motion in there. I don't think I have. I'll have to double check on that. I want to talk to you guys about the jurisdictional challenge with an affidavit. For those of you who are using that, the one thing that you need to make sure of is you need to make sure that you don't allow them to turn your non-conventional attack on their ass into their conventional BS. And I say that, what I mean is when you file a jurisdictional challenge with an affidavit, if you read it and you understand it, you're directing the judge to force the other parties to prove jurisdiction on the record. And your motion to moot until all of the pleadings filed in the case, until jurisdiction is proved on the record, it's not something the judge should even be ruling on, okay? And if the judge is ruling on it, then they don't have no respect for you, and something's going on, and we'll figure out how to handle that with this new addition to the package. The first thing is, as soon as the judge violates you, you have to do something about it. You file a motion, all of the reconsideration, that whole thing. If you do nothing, then they're going to keep messing with you. That's how it goes. You can ask anybody that's doing it. If they didn't attack the judge when the judge first threw them under the bus, the judge keeps throwing you under the bus. And I'll tell you why. The judge knows that probably after the pandemic, probably 95% of us can't afford an attorney. And those who can't afford an attorney are going to get thrown under the bus in the end. So the judge knows, and all the people all the players know that they got a 95% chance of working this out and not even have to do anything. So they're just going to keep throwing you on the bus. What are you going to do? Until you show up with the fire. So yeah, that's the way they look at it. So when you start your case, you need to be on it. As soon as they start giving you a hard time, you need to do something about it. And the first thing I tell them, hey, my legal team said this, my legal team said that. Smell Maxwell in our Facebook page, she did a great job. I was talking to her the other day, and I asked her, I said, Smell, I want you to think about this, and I want you to answer and tell me how many times you think you called down to your courthouse and talked to the clerk about the BS they were pulling on you and your dad when they were trying to kick him out of his house. And she thought for a little while, and she said, well, Mr. Guy, I think I called her every day. And she said, they finally got around when they answered the phone, hello, Miss Maxwell, yeah. So, but you have to be willing to do that. When the stuff wasn't right, she was on the phone calling down there. Now, people don't realize that the clerk is one of them. And the clerk act like they're your friend. Oh, yeah, they're really nice. And yeah. And then they're not filing your stuff when they're supposed to. They're telling you your stuff was lost. when they were the ones that went and picked it up and signed for it? Yeah. So the jurisdictional challenge with an affidavit do not allow those players to turn your strategy into their conventional BS. And when I say that because what's happening is people are filing it, the jurisdictional challenge with an affidavit. So if it's not responded to by counter affidavit, then it's not responded to. And the judge can't answer for them. That's BS. So this happens because people file this jurisdictional challenge with an affidavit and they wait for an answer. Well, that's what you're supposed to do, but there's a time frame. So anybody that tells me that you don't have to answer until the judge tells them to answer, no, that's BS. Okay, that's in their conventional crap. Those are the local rules that they put together to help attorneys run your butt through court faster. And those are not any rules that we need to be even worried about. There is a time frame that people have to respond in court. And I could tell you what it is, but my job is not to make it easy for you, okay? So you're gonna have to figure it out. And the easiest way to figure it out is to look up the civil rules of procedure, look up the rules in your state. I would make sure I'm looking at the civil rules of procedure and not the local rules, okay? And figure out what that time frame is. And if they do not respond to your jurisdiction, and I'm talking about the attorney, not the judge. If the attorney does not respond in the time frame allowed, the next day after the time frame is up, you should be in court filing something. Yeah, I'm going to let you do your homework on that too and figure out what you need to file if they don't respond. Because people call me, oh, they didn't, what do I do? That's not my job. My job is to set you up with a strategy. Your job is to figure this stuff out. And all you got to do is get on Google. You'd be surprised what you can find on Google. Now, you get on Google, you figure it out, you call me up, you say, hey, this is what I got. I got this paper from the court. I went through it. I looked up the words I didn't understand. I think I understand what they're doing. And this is what I think my strategy should be. That's what I like to hear. Okay. That tells me you're done with the fear and you're figuring out what you need to do to step on somebody's face. Okay. Because this whole process is fraud that they're doing to you. And if you have somebody coaching you, showing you where the fraud is, all you got to do is learn what's on the paper so that you can speak it when they get in your face or when you got to get in their face or wherever, how that goes. Hopefully you're getting in their face. So it's important to make sure you understand the document inside and out. And it's important to make sure you understand why you're filing it. It's important to make sure you understand what they have to do to respond properly. It's important to make sure you understand how long they got to respond. It's important for you to understand what you need to do if they don't respond in time. Now, this is very important because if you let it sit there, the judge is going to think, well, they don't know what the hell they're doing. She's letting it sit there for me to rule. Yeah. And then they'll rule. And I have two judges now. One judge hasn't ruled to dismiss the jurisdictional challenge, but the judge ruled to dismiss the motion to moot everything until it's proven on the record. And that judge needs to be sued right out. I would not even waste my time doing the reconsideration or whatever. I would file it, but I would file a lawsuit against the judge. After you want to get your stuff on the record that they ain't doing right. Now, when the magistrate judge looks at your stuff and decides it needs to be dismissed, they usually dismiss it under Rule 12B for failure to state a claim. And in my opinion, the main reason why they get away with that is because most people make the biggest mistake most people make is they don't have the attorney on the lawsuit anywhere. So the courts know that you're never going to have a chance to hold the right person accountable when you don't have the attorney as number one defendant, so they're going to throw your stuff out. But the problem here is when the judge is throwing your stuff out, what the magistrate judge does, without consent from all parties or jurisdiction is they write a report. The magistrate judge writes a report, and the report is sent up to the district judge. And the district judge looks at their report and says, oh, I need to dismiss this according to the report. So the judge dismisses it according to the report. And most people fall for that shit. But here's the problem. The problem is if they're in administrative court. If the judge don't make a finding of facts and conclusions of law along with his order, they're in an administrative court. Check your paperwork. It says right on there. It was the order to dismiss. It says right on your paperwork that the magistrate judge's order to dismiss, and then the other judge dismissed it. But nobody catches that. That's like messed up because you weren't even in a judicial hearing. You're in an administrative hearing. And a judge that didn't have any jurisdiction without consent is making an order to dismiss. And the judge is dismissing it up here without even looking at your stuff to see if it should be dismissed. Yeah, that's a problem. And that's one of the things that our package takes care of. So you want to make sure you do not allow the players to turn your program into their program. And you need to do that by keeping track of the time frame and jumping on stuff. When they don't respond in time, you need to step up and do something about it. Now, if the time frame passes, the judge will take control because he's figuring you're waiting for him to rule or her to rule. So the judge is going to take control, and he's doing that because you failed to address the fact that the time frame passed. What's the time frame? You're going to figure that out. You're going to figure out what the time frame is for your state. I would figure out what the time frame is for the federal time frame because I don't do anything according to the state. As a matter of fact, if you pay attention to the documents that you purchased from me, that you invested in, we only use federal law in those documents. And state court hates it. There are some documents that are put together to be filed in state court, and we use federal case law in them. And I have the case law that allows you to use federal case law in state court. It's no different than using Supreme Court case law in any court. But attorneys don't like it. The judge hates it because it bounds them to precedents, or at least it's supposed to, if you're in a judicial court. So that's what we're talking about on that. So the time frame to respond, you need to figure that out for your state. What your options are for non-response, you need to figure that out. Now, you figure these things out, put together your game plan, give me a call. And then we can talk, and you can say, hey, this is what I got going on over here, blah, blah, blah. And it's not going to take, I'll know pretty much right off if you're on target or not, because I've been doing this for a while. And just from having you tell me what's going on, whatever, I'll know. And I'll be able to tell you, dude, great job. Well, we might want to tweak this or change something. The goal here is for you to learn how to do this yourself, not for me to tell you everything that you need to do, okay? Because that's what attorneys do. And I ain't trying to do that because I ain't charging you enough money to do that. Okay, the goal is for you to learn, okay? By doing things the way I'm doing them now, I can help a lot of people. Eventually, we're going to be doing Zoom calls and all of that. If I do things the way attorneys do things, I can help just a very small handful of people. And those people have to pay me a lot of money. Okay, we're getting back to the attorney thing. I think you guys get the picture. So let me head back over and take a look and see if I have some people watching, a couple of people. Okay, who's here? So on Wednesday and the radio show, we're going to talk about how to take care of the judge situation. And that's going to be one of the main subjects that we talk about on the radio show. And I am also, I'm going to offer another sweet deal, just like I did last week when I put the property tax deal up for $100. Well, this one won't be $100, but I'm going to offer a sweet deal on the lawsuit packages on both of them for the weekend. Hey, Kerry Jackson. And so you guys are going to need to be paying attention to see what that deal is. And the deal is only going to last for a short amount of time. And when that time is over, the deal is going to be done. And I won't be able to hear anybody crying because I'm giving everybody a fair shot. And what I'm doing is I want people to be able to use the document. I would like people who get this deal and who got the deal from last week on the property tax packages, I would like people to leave a review after you had a chance to check out the paperwork. And the first review should be about the value of the documents. If you think I got it going on right, whatever, how you feel about the documents. And I would like you to let everyone know that you're going to do a follow-up on the progress. Okay, because what I do, most people end up either settling or the attorneys go sit the hell down, and sometimes it gets dragged out for a while. Then there's one goal if you just stay in your house. So it's not fair to make me wait all the way until your stuff is completely over before you leave a review. And I'm only asking you to leave your opinion of the documents that you got after you review them. And I think that's fair. I'm not asking anybody to say they won anything or any of that kind of crap, because it ain't about winning. It's about staying in your house and kicking some people in the face. I used to say punching, but I don't want people to think that I'm violent. So if I kick people, I think that's less violent than punching. Okay, never mind. That sounds like I'm about to get myself in trouble. So the notice of claim for a violation of the Administrative Procedures Act is the best thing, in my opinion, that you can stick up in the judge's face, because that is the tool that you can use to force their corporation to change their policies and procedures to be in line with the Constitution. I know that sounds crazy. People told me I was crazy a long time ago when I started learning how to help people in foreclosures and tell people, yeah. And those same people now aren't telling me I'm so crazy. So, or maybe I am a little crazy, but crazy like a fox. Yeah, there you go. So that's the best thing that you want to bring if the judge is giving you a hard time. I'm going to do a screen share and show you guys what the lawsuit package is look like now, so you'll have an idea of what you're going to be getting when the deal starts. So let me see here. I need to do a screen share. And I need to share that screen. Bingo. There we go. So this is the non-judicial lawsuit package now. I added this to it. But before we get to that, we're just go over these. This is the inventory cease and desist letter. This is a letter that you can use when they first send you your stuff, or you can use this letter when third-party debt collectors are getting up in your face. This letter works great if you've completed the passport process, or if you have filed your affidavit of state citizenship to reclaim your state citizenship. This works great. This is demand to strike the notice of appearance of the attorney. This is the document that you would file when the attorney can't find someone else, an outside attorney, to help them, because you've added the attorney to your wrongful foreclosure / breach of contract lawsuit as a number one defendant. And this one is a motion for sanctions. You want to wait and file this later, or depending on your strategy and your situation, to motion for sanctions. If they did find another attorney, and I've had this happen once, they found an attorney from out of state, and then we filed the motion for sanctions and stuck that in their face. The motion for sanctions is for $5.5 million, and the attorneys are supposed to do a reasonable pre-file investigation before they come after you, and they never do. And a lot of times they don't even file an affidavit. So that motion for sanctions jams them up. It's kind of like a mini lawsuit inside of another lawsuit. And attorneys don't do stuff like that, but we sure do. The notice of default, this is what you would file when they don't respond. Oh, damn, I just let the cat out of the bag on that. Okay, so maybe I'm making it a little easy for you guys. The non-judicial restraining order. The restraining order you can use if you're facing eviction or if they're trying to sell your house. You have to be able to show that you're in immediate harm before you can use the restraining order. And then the wrongful eviction order, this is the non-judicial package. If you've been evicted, you can use this. You can use the wrongful eviction as your lawsuit. If you've already been evicted, you can still get this package and use this to get yourself back in the door. The affidavit template, this is what it says. The civil cover sheet answers, they're numeral numbers, and the answers next to the numbers are the answers that go on their form. Now, their form, when you're filling out their forms, they will try to get you to fill out the lawsuit form and all of that crap. Okay, no, I would take that lawsuit. They have a lawsuit form. I would stick it in your notebook behind everything and keep it. I would not even hand it back to them, because if you fill it out and you hand it back to them and you give them your lawsuit first and you hand them that, when they go over there and file it, they're going to file their stuff on the top, and they're not even going to pay attention to the other crap that you got on the bottom. And the problem is that little form they give you don't have no answers on it that's going to help you get anything done, and that's why they like to use it. Now, you do have to do the civil cover sheet and the summons and all that stuff. There's stuff that you have to do, but you do not have to fill out their lawsuit form. And this is what it is, a lawsuit form. This is the lawsuit, the wrongful foreclosure / breach contract lawsuit, the motion to challenge jurisdiction. This motion is a challenge jurisdiction of eviction court. And then you have a notice of removal to remove the case from eviction court over to federal court to be connected with your, the notice of removal is right here. And when you file this, when you file the motion to challenge eviction court's jurisdiction, you want to take a file stamp copy of that motion and attach it as an exhibit to the notice of removal. And then you file the notice of removal in federal court, and you tell them to connect it to your title dispute. Because here's the deal, eviction court cannot make a determination on a title dispute. They can only rule on immediate possession. Okay, and those other fools usually have a piece of paper that they got from the court or that they fraudulently made up showing it's a new deed or whatever, and that's how they get away with that. They move the eviction process to like municipal court. And municipal court, or that court, whatever you want to call it, does not have jurisdiction to hear anything about property. If they did, they'd be able to hear a title dispute. So when you file a title dispute, that blocks the eviction process. That's how we got around that. You file your title dispute in federal court, and then you use that to block the eviction process by removing the eviction process from from state court over to federal court. And when you file this stuff in state court to remove it, you don't wait for the judge to respond. You file your shit, and the next day you go and take that stuff and you file it over in federal court. Now, when federal court gives you a hard time, you tell them, look, the title dispute robs the lower court of jurisdiction. The title dispute's in this court. Now, the second part of this is this. The eviction court can only hear immediate possession. And immediate possession cannot be determined until the title dispute's settled. So if you guys could connect this with my title dispute, and when I get done whooping these people's ass, then you guys can make a determination. Then we won't have to worry about it. And I have had one case where they didn't want to do that. And that one case, the person got violated by the judge in the beginning and didn't address it. and that person is now addressing it. And Rudy's doing a great job. And he's also in the Facebook group. So you guys need to keep that in mind. The entry of appearance is something that you would want to file after the entry of appearance. I would use if you had an attorney that was throwing you under the bus and you need to make sure that attorney's out of your face, then you would use this entry of appearance. And that's notice of removal. Now, what I've added to this is the new magistrate reconsideration package. So let's open it up and take a look at it, baby. Okay, here we go. You got to click on it twice. Now, in this, you have the new objection and notice of claim against the judge. And I'm just going to open that up so you guys can see that we ain't playing. I have people get all nervous and all, dude, no. You have no idea how much power you have if you have the courage to freaking use it. So this is what this looks like. Now, you want to replace the red font with your information and turn the red font to black, and obviously delete the instructions. So we're just going to go over the first page here so you can see notice of claim against the judge. That should be in red. You'll have to change the judge's name. And if I miss something that should be in red or that you need to personalize and change, just do it, but don't delete stuff or take things out. Be smart about that, because you don't understand everything that I've got going here. And I wouldn't want you deleting something that's going to allow them to get a jump on you. But like, for instance, here, the judge's name should have been in red. That you're going to need to replace the judge's name unless your judge is Judge G. Hawthorne. And I don't think it is, because I made that up. So okay, sorry. So you're going out there for violation of the Administrative Procedures Act of 1946, obstruction of the administration of justice. That's important. Most people say due process violation. And my friend that coached me to where I am now told me that it's not due process violation. That's for criminal court. In civil court, you want to say they're obstructing the administration of justice. And when you say that, those fools know that you got a legal team. And violation of a constitutional right under the color of law for making a determination without jurisdiction. See, I like to keep it simple. They made a determination without jurisdiction. They don't have jurisdiction if you file that jurisdictional challenge with an affidavit, and it says right in it that the attorneys are supposed to answer, and it's supposed to be answered by counter affidavit. If you file something with an affidavit, and judge gonna try to do all that stuff and answer, no. It's time to turn the fire up a little bit. So that's what the claim looks like. And this one is, I don't know, several pages long. I don't know how many pages long, but it's several pages long. The magistrate judge consent form, I added this so people can see it, because most people, I have people that didn't think that was true. Notice of assignment to the magistrate judge. And you can see right on there, you can read it real quick before I switch it over, that please attach indicated whether you consent to proceed before assigned magistrate judge. This form is also, so you have to consent. If you don't consent, then the magistrate judge is in violation of some stuff in accordance with the provisions of 28 U.S.C. section 636C. I voluntarily consent. So if you don't consent, they're in violation of 28 U.S.C. 636C. Yeah, I like to keep it simple. Use their own stuff up in their face. Oh, this is a nice one. I like this. This is the notice of recusal. to recuse the magistrate judge or any judge that's violating you. So I got the magistrate judge on here because that's kind of what this package was for. But it don't matter what judge it is. It don't matter. Now, the thing people need to remember about this is people get freaked out. They think, oh, the judge has complete immunity, blah, 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 blah. Well, the judge don't have complete immunity. The judge has qualified immunity as long as they're following the law, as long as they're operating within their jurisdiction. Well, we already proved they ain't doing that. And you already know they ain't following the law. So no, the judge does not have immunity. So when you recuse a judge, you do not have to prove that the judge has been impartial. All you have to prove is the appearance of impartiality. And that's real easy with most of the cases that I've been helping people with. That's been real easy to do. That's all you got to do. And then, move to recuse the judge. You want to move to recuse the judge right before you file your lawsuit against them. And when you file your lawsuit against them, you want to take your file stamp copies of this and all the other stuff and attach it to your lawsuit as an exhibits. Everything is to be attached as exhibits. As a matter of fact, your challenge to your jurisdictional challenge with an affidavit eventually will be attached to your lawsuit as an exhibit to prove in federal court that state court had no jurisdiction to even be up in your face in the first place. And if you can do that by the documents in the lower court, then federal court don't need to have a trial. They just need to have a settlement hearing. You get that on the record in federal court, then I move to court for a settlement hearing. Why waste the court's time? If you've already proved in the lower court that they're up in your face messing with you. Yeah, I like to keep it simple. So let's look at now. We got a couple of people here. AJ Entertainment. Hey, AJ, what's up? So we're going to wrap this up here in a couple of minutes. So I left some notes on the magistrate judge's consent. So you can kind of understand a little more about it. And these are their notes, so they're pretty accurate. And I also gave you a notice of appeal template that you can use. When I don't do notice of appeals and all that. As a matter of fact, I have no faith in any of that. But sometimes you can use this strategy to buy yourself some time until you get yourself in position to do what needs to be done. So now, I'm not going to spend a whole lot of time going over the judicial, but we're going to look at it. Because it's important. Because the documents are pretty much the same, except there's obviously, as you can see, more documents in the non-judicial package because of the fact that the whole front half of the whole foreclosure part is done outside of court. The only time you get into court in a non-judicial foreclosure is when the eviction process is started. So this is what it looks like. You got your restraining order. This is your lawsuit, demand to strike, motion for sanctions, cover sheet answers, instructions for the foreclosure package. Now, I also have a playlist on my YouTube channel, instructional playlist that you can go to and get the instructions for all of the packages that I have listed on my website. And then this is a lawsuit against third-party buyer. If there's a third-party buyer involved, you can jam them up. And then I've added this, the new magistrate judge reconsideration package here, and it's exactly the same that we just talked about a few minutes ago. So I'm not going to spend a whole lot of time going over that, but I want to show that so people can see what you're getting when you make your investment into our program. So well, that's all I got tonight. I just wanted to talk a little bit about the jurisdictional challenge with an affidavit and make sure people understand that you don't want to wait and allow them to respond. You want to figure out how many days they have to respond to your stuff. And if they're 1 hour short, you want to be in their face with your stuff, filing your motion to motion for default. And I also have another document too that some people may need, but not everybody needs it. So we'll talk about that at a later time. So I want to thank you guys for listening tonight, and I'll be back Saturday night. So not sure what we're going to talk about, but I'm sure I'll have something to talk about. We should have a pretty good show on Wednesday. So you guys make sure that you tune in for that tomorrow. And I'll leave a couple of links over here in the window. HamiltonRadio.net. And that's the radio station that we're going to be on tomorrow. And the call-in number is 609-585-0400. So it would be great if some of you guys that are in the program, if you could call in and tell everybody how things are going with you and what you think about our program. So that's all I got tonight, guys. I will see you guys in a few days. Good night, all. Need to figure out how to turn this puppy off. There we go. And now we got it going. In the stream.